light of the pandemic. But for purposes of victim rights, I want the court to know that Mrs. Manley is not in support of moving the trial. She would like to have the matter resolved.
Did she want to be heard on that?
Let me find out. Do you guys want to talk about that? You'll need to come off of mute if you want to talk to the judge about that, Meredith. David, can you unmute her microphone? Can you unmute the microphone, David?
I can do it.
Oh, okay.
Well, maybe. I tried to, but I think he might need to.
Okay.
There you go. I think we're on. No, we're still muted.
Is that better? Can you hear us now?
There you go. Well, we can hear you now.
Okay.
Okay. I forgot. I don't want it delayed. It's been a long time. It's been over a year that we've been not even meeting with this. They just keep putting it off, putting it off, putting it off. And I'm not getting any younger. So I think this needs to be taken care of.
All right, Ms. Wilson, did you want to respond to the victim opposing the adjournment?
No, Your Honor. I think she's stated her position on it.
Your Honor, may I be heard just briefly?
Sure.
I would note that Mrs. Manley is 83 years of age and certainly in a population group that is most susceptible to COVID. I just wanted to point that out to Your Honor.
As far as the motion to adjourn, the issue is really good cause, whether there's good cause to adjourn the trial. The state isn't objecting to it. I certainly take into consideration the victim's statements, and her statements are, you know, there is something to be said about somebody who's in their 80s, and it's certainly not at the beginning of somebody's life. It's getting towards the end. We have had cases where we've had some considerations of people that are older than the normal course in their 80s, and arrangements can be made for people for videotape depositions if their health isn't very good. I've done those before, so that's certainly an option to preserve the testimony from an evidence standpoint. And I certainly understand the victim's request to wanting it done sooner rather than later. These aren't, you know, this isn't a brand new file for any stretch of the imagination. But quite frankly, if with the COVID situation and not knowing whether or not we're going to have a trial, we could wait for a couple of weeks. But we haven't had a plan approved by our chief judge of the district to say we can have jury trials. So even if I wanted to keep it on for a jury trial, the problem would become I wouldn't have, then we get 2 weeks down the line and I adjourn the trial because the chief judge says no. As far as I know, there's very few places having trials at this point, and I just hate to keep people waiting for a couple of weeks to see it would happen. And people are a little bit apprehensive about coming to large gatherings, which a jury trial would be. I think we've worked out the logistics of having a jury trial, but I don't think it's in anybody's best interest for us to do a stop and go. And quite frankly, 2 weeks from now, maybe I'm not going to have the same trial availability and can't get it back on the calendar as quickly. So under the circumstances, I do believe there is good cause to adjourn the trial. And I think even our Supreme Court has acknowledged that based upon not having a plan approved to go to trial, that's good cause by itself. So I will grant the motion and to adjourn the jury trial. As far as scheduling goes, how far out were you thinking, Mr. Gondik?
Do we dare set it for this summer yet, or what's your feel, Judge?
I think if we look into, I think the next 2 weeks will kind of be a telltale symbol 2 weeks to a month, whether they shut us down more and we don't do jury trials or not. At least we have the option, but I would hate again to do it too soon and then us not be able to have the jury trial. But I would think in later July or in August, we could probably accomplish a trial. Right now, looking at my calendar, I have no jury trial scheduled for August 25th. And I would think if there was a date that I would feel fairly comfortable that we'd be able to have a trial on, as long as things don't go south, I think August 25th is a good date.
We can make that work for the state for sure. I mean, assuming Mrs. Manley, is that okay with you? August 25th? David, she's on mute again. We still can't hear.
There.
There we go.
Can you hear us now?
Oh,
Is
I
August,
think I waited. I think it should be in July. I've waited a long, long time. And it's been stall all the time. And I just think this has gone long enough. It's just, they're just stalling from 1 month to next month to 2 months, and nothing has been really accomplished on their part.
if we do set the trial for the 25th of August, is that a day that you could be here, Meredith?
Yes, but I would rather have it in July.
Okay, and I understand that, and the judge can hear you too. It sounds like that the calendar is looking like it's going to be the 25th of August.
Well, Ms. Wilson, I'm sorry to interrupt you. I'm looking at my calendar for the 25th of August, and I have a Minnesota case that is scheduled for mediation that day with multiple attorneys. And that's a Minnesota case, so I can't send my son Garrett over on it. I just note that.
Let's go off the record then for purposes of scheduling. And the problem is, I mean, I'll be realistic. If we do it in July, I've got a sex predator discharge jury trial, and unfortunately, because that person has precedence because of time limits, that would take precedence. So, and I've got another gentleman that's in custody. So even if I did a July one, I'm not confident we'd even be able to do a July one if that, in fact, even if they take place in July. So I certainly understand the victim standpoint, but I don't know that it's realistic with my calendar. But I could do, I've got some other dates.
What about the first part of August?
I've got time August 3rd. How many days do you think, Ms. Wilson?
I think it's probably just a one-day trial, Your Honor.
Oh, Judge, there's no way.
Oh, okay.
Yeah, there's no way. I was gonna say 2, which means it's probably gonna go 3. I'm always 1 day short in my projections, but at least I'm consistent. So I would say, Judge, if we set it for 3, it'd probably be wise.
I mean, the issue is I could again schedule it August 4th for a 3-day trial. I've got 2 other civils scheduled those days, and one of them is a 2018 case. So I'm not sure that we would actually have a trial that date. So I could do it those dates. Then if
One
we
of
look,
those is mine, Judge.
okay,
Ledoux, you got Ledoux on there?
I've got Ledoux, and that's a 2019, but I also have a 2018, which is a Bullock and White.
Oh, okay.
I mean, I could schedule it that date. What do you think, Ms. Wilson?
We can certainly be ready that day, and then if you have to move it to a later date in August, we'll be ready then too.
Ms. Manley, is that what you'd prefer, that we schedule at that date, but if for some reason one of those other trials go, we just move it?
Yes, yes.
Okay. All right, so then why don't we pre-try it? So August 4th at 8:30 with a pre-trial conference. How about July 17th at 3:30?
That'll work for the state. Does that work for you, Mr. Gondik?
I'm sorry, was that 3:30 on the 17th, Judge?
Yes.
Those, yeah, those should work just fine.
Okay. We'll
And then
go
were you
back.
setting it for 3 days, Judge?
Yes.
Okay, thank you.
We'll go back on the record, spoke to the parties off the record and the victim. We've decided on August 4th, starting at 8:30. I'll schedule a matter for 3 days. The pretrial conference will be July 17th at 3:30, and I will get a new scheduling order out the next week or so. And we had a discussion off the record. I know originally I had talked about the end of July, or I'm sorry, the end of August, or even potentially July, but with my calendar, this certainly wouldn't take precedent over some other cases, unfortunately. But as far as the August date, as I indicated to Ms. Manley, we could certainly do it, but I have some concerns that I've got two other civils that also, one of them is a 2018 case, which is older than this case, so I'm not sure that this one would for sure go. She wanted it done as soon as possible, which I certainly understand, so we've made those accommodations. I guess we'll see what happens. Ms. Wilson, that all works for you?
It does. Thank you, Judge.
And that worked for the victim?
Yes,
Yes.
And I adequately stated for the record what needed to be said, Ms. Wilson?
I believe so, Your Honor.
Mr. Gondik, that works for you?
It does, Your Honor.
All right, anything else we need to address today, Ms. Wilson?
Not from the state. Thank you.
Well, I guess, and it was just the amended information, I guess. Mr. Gondik, under the circumstances, then are you objecting to it or not?
I mean, I would point out, I would formally object based on the length of time from the filing of the original information until now. That's one of the factors that the court has to consider, but I'm well aware of the law in the area.
All right, anything else, Ms. Wilson?
Our response would be, Your Honor, that the defense has had from the beginning the discovery that takes the crimes back to 2015, as is reflected in the amended information. The defendant is not prejudiced by this, and now there is additional time between now and the time of trial for them to carefully review those records. So we believe there would be no prejudice, and so we would ask the court to allow us to amend the information to reflect the dates in the amended information.
All right, under the circumstances, I'll grant the motion to amend the information as requested. There doesn't seem to be any prejudice involved. I know that the length of time has been there, but quite frankly, sometimes information to reflect the evidence amendments get made even during the trial. And even after the evidence has been completed, as late as just before it goes to the jury. So I've seen those things happen. This certainly gives the defendant plenty of time to do any adequate investigation. And again, this is being adjourned for a couple of months, so that should give adequate time. So I will grant that motion. I think that's it. Anything else, Mr. Gondik?
Nothing from the defense, Your Honor. Thank you.
I think I hit it, Ms. Wilson. Anything else from you?
No, thank you.
All right, and I'll get that scheduling order out. And if you want to do an order, Ms. Wilson, regarding the amendment of information, I don't know if you want to put an order together at all regarding other acts, but I'll leave that up to you.
Okay.
I think that's it. Thanks.
Thank you.
Thank you now.